would pause just a moment to it. If you would just pause so it gets started. We're ready, Madam Chair.
Great, thank you so much. The meeting on the Commission on State Mandates will come to order. Welcome to the webinar. Statutes of 2022, Chapter 48 amended the Bagley-Keene Open Meeting Act to extend until January 1st, 2023, the authority to hold public meetings through teleconferencing and to make meetings accessible electronically to all members of the public seeking to observe and to address the state body in order to protect the health and safety of civil servants and the public. The Commission continues its commitment to ensure that its public meetings are accessible to the public and that the public has the opportunity to observe the meeting and participate by providing written and verbal comment on Commission matters. Please note that the materials for today's meeting, including the notice, agenda, and witness list, are all available on the Commission's website, www.csm.ca.gov under the Hearings tab. Also, please note that in the event we experience technical difficulties or the meeting is bumped offline, we will restart and allow time for people to rejoin before recommencing the meeting. And with that, Ms. Halsey, will you please call the roll to establish a quorum?
Sure. Mr. Adams?
Here.
Ms. Miller?
Here.
Mr. Morgan?
Present.
Ms. Nash?
Here.
Ms. Olson?
Here.
Mr. Silva?
Here.
Mr. Walker?
Here.
Great, we have a quorum. Next, we will go to item 1. Are there any objections or corrections of the minutes from September 23rd, 2022?
Move adoption.
Thank you, Ms. Olson.
Second.
Thank you, Mr. Walker. Any public comment? It's been moved and seconded. Ms. Halsey, will you call the roll, please?
Mr. Adams?
Aye.
Ms. Miller?
Aye.
Mr. Morgan?
Abstain since I wasn't there.
Ms. Nash?
Aye.
Ms. Olson?
Aye.
Mr. Silva?
Aye.
Mr. Walker?
Aye.
Great, the minutes are adopted. Ms. Halsey, public comment?
Now we will take up public comment for matters not on the agenda. Please note that the Commission may not take action on items not on the agenda. However, it may schedule issues raised by the public for consideration at future meetings. We invite the public to comment on matters that are on the agenda as they are taken up.
Is there any public comment? Ms. Palchuk, just making sure you don't see anyone using the raise hand feature.
I see none, Madam Chair.
Great, thank you. Seeing no public comment, we will move to the next item, please.
Let's move to the swearing in. Will the parties and witnesses for items 3 and 4 please turn on your video, unmute your microphones, and please rise and state your names for the record. One at a time, please, because we need to get that for the record, for stating your names. Okay. Annette, if you want to begin, that'd be fine.
Annette Chin, Cost Recovery Systems Consultant for the City of South Lake Tahoe.
Mr. Mercurio?
Yes, good morning. My name is Chris Mercurio. I'm with the Public Defender's Office.
Thank you. Mr. Lemus?
My name is Fernando Lemos. I am the claimant representative for the County of Los Angeles.
Thank you. Lieutenant Roberson?
I'm Jeff Robertson. I'm the investigative lieutenant at South Lake Tahoe Police Department.
Thank you. Ms. Kearney?
Lisa Kearney, Compliance Audit Bureau for the State Controller's Office, and I'm the audit manager.
Thank you. And Ms. Gonzalez?
Hello, Lucia Gonzalez with the Office of County Counsel on behalf of claimant Los Angeles County.
Thank you. Did I miss any witnesses for items 3 or 4 who did not introduce themselves? No, okay. Will all of the witnesses please raise their hand? And for the swearing in, do you solemnly?
Miss Halsey, I'd like to stop you a moment. I see that Mr. Osaki is here in the public link. So I think.
So
we
he needs to be
pause.
made a panelist.
Yeah, I think we need to pause one moment, please, and we will let him in. Mr. Osaki, if you can hear us, I switched you to a panelist and now you are on. So if you would please turn on your microphone and turn on your camera and state your name for the record, and then Ms. Halsey will swear everybody in.
Okay, can you hear me? My name is Craig Osaki.
Yes, sir, we can hear you. Do you have a camera video?
Trying to turn that on right now.
Oh, there you go.
Okay,
Thank you. And Mr. Osaki, you're testifying on behalf of?
the LA County Public Defender's Office.
Great, thank you. For all witnesses now, please raise your hand. Do you solemnly swear or?
Ms. Halsey, I'm sorry, I need to stop you again. I see that Ms. Olga Tikamarova is also in the public section. Ms. Olga Tikamarova, Ms. Chin, is Ms. Olga Tikamarova going to be a witness on today's meeting? We had her on the witness list.
Yes, correct.
Okay, Ms. Tikamarova, I am going to switch you over to panelist and you will appear on the screen. And now we would ask you to please turn on your microphone and turn on your camera for the swearing. And if you would please state your name for the record.
Olga Tikhomirova, City of South Lake Tahoe Finance Director.
Thank
Ms.
you.
Halsey, I
Sorry,
believe we are
this
all
is
here
the-
now.
This is the court reporter. Ms. Tikamarova, can you please repeat that and speak up a little bit for me?
Olga Tikhomirova, City of South Lake Tahoe, Director of Finance.
Okay. Third time is a charm. Please raise your hand for the swearing in. Do you solemnly swear or affirm that the testimony which you're about to give is true and correct based on your personal knowledge, information, or belief?
I do.
Yes.
Yes.
Thank you. Please be seated, and parties and witnesses for item 4, please turn off your video and mute your microphones. Item 2 is reserved for appeals of executive director decisions, and there are no appeals to consider for this hearing. Next is item 3. Commission Counsel Mariko Katani will please turn on her video and unmute her microphone and present a proposed decision on a test claim on juveniles custodial interrogation. Department of Finance, contacted the commission and let us know that they will not have the opportunity to attend this hearing today.
Good morning.
Good morning, Ms. Katani. Thanks for being here.
Thank you very much. Good morning. This test claim was filed by the County of Los Angeles on Welfare and Institutions Code, Section 625.6, as amended by the test claim statute. Prior to that statute, existing law required law enforcement to provide a minor with legal counsel upon the minor's affirmative request. Existing law also required counties and cities to ensure that youth, ages 15 and younger, consult with legal counsel prior to custodial interrogation and before the waiver of any Miranda rights. The test claim statute extended that requirement to youth ages 16 and 17. Staff finds that the test claim statute imposes a reimbursable state mandated program on counties and cities to ensure that youth ages 16 and 17 who do not affirmatively request an attorney consult with legal counsel prior to custodial interrogation and before the waiver of any Miranda rights. In instances where the youth does
And
not
Ms.
have a private
Cotton,
attorney.
this is the court
Yes,
reporter again. Please just slow it down a little bit for me, please.
Apologies, would you like me to go over
Ye-
that entire bit again, or?
No, you don't have to do that.
Okay,
To ensure that youth ages 16 and 17 who did not affirmatively request an attorney consult with a legal counsel prior to custodial interrogation. And can you
And-
just pick it up from?
got that. Thank you very much. And before the waiver of any Miranda rights. In instances where the youth does not have a private attorney, this includes providing legal counsel to consult with the youth in person, by telephone, or by video conference. Accordingly, staff recommends that the commission adopt the proposed decision to approve this test claim and authorize staff to make any technical, non-substantive changes following the hearing. Thank you, and apologies to the court reporter.
Thank you very much, Ms. Katani. Mr. Is it Briscoe, the court reporter? Are you okay to proceed?
Yeah, that
Great,
was
great.
perfect. Just need people to take it a little slower than you usually would. People tend to read much faster than, they normally talk.
Okay, got it. All righty,
Thank
if you want to go ahead and mute yourself, thank you. And now if the parties and witnesses could please state their names for the record. So we have Mr. Lemus, Ms. Gonzalez, Ms. Mercurio, and Mr. Osaki. I'm so sorry, is it Osakai? Please correct me. For the County of Los Angeles, would you like to begin? If we want to
Okay,
go in that order.
Okay, yeah, this is, my name is Fernando Lemus. I am with the County of Los Angeles Department of the Auditor Controller. I am the claimant rep for the county. And I'm here to state that the county agrees with the proposed decision. I believe we have one minor point of just clarification, but I'll turn that over to the folks that accompany me. So I'll turn it over right now to Ms. Gonzalez so she can introduce herself. Lucia?
Yes, Lucia Gonzalez, again with the Office of County Counsel, and I'm advice counsel to the Auditor Controller. I will not have any statements today. I'm available for any questions that the commission may have. But at this time, I will turn it over to our colleagues at the Public Defender's Office.
Thank you. Is that Mr. Mercurio and Mr. Oskai?
Yes, good morning. My name is Chris Mercurio. I'm a head deputy with the LA County Public Defender's Office, and I've supervised the Juvenile Miranda program where we provide consultations to youth.
Great, thank you. Any comments you'd like to?
Well, we agree with the decision. There is a minor point of clarification, which Mr. Osaki, my colleague, will address.
Great, thank you, Mr. Mercurio. Mr. Osaki, please.
Yes, my name is Craig Osaki. I'm also with the LA County Public Defender's Office. And we agree with the proposed decision in that the test claim statute creates a new state mandated program. But we do wish to clarify one point. The Public Defender's Office is appointed on the case at the arraignment when the minor is officially charged with the crime. And that is when our obligation to defend begins. During the period of time when a minor is being interrogated, that is all being done prior to the arraignment. So this test claim statute requires law enforcement agencies to contact the PD's office or our office if they decide to conduct an interrogation. So the county is now required to act prior to the appointment at the arraignment. And this far exceeds what is required by the Constitution and the law. So the previous law just simply required just the notification by the peace officer of their right their right to counsel, right? And now the law requires consultation prior to the interrogation. So we are obligated to provide this consultation whether or not the minor affirmatively asks for an attorney or not. So that's the only little clarification that we wish to make, because in the commission proposed decision, the test claim statute, there's various passages where the decision states that the statutes are only new with respect to 16 and 17-year-olds who do not affirmatively request counsel. And it's just important to note that this law is not contingent on whether or not they affirmatively request counsel. Once the police officer decides that they want to conduct an interrogation, that decision triggers a new obligation to contact us, and we now have to respond at that point in time, whether or not the minor affirmatively requests counsel or not. Once that police wants to interrogate the minor, that is when they are required to contact us. So that's the minor point that we wish to make. And thank you for your time. If you have any questions, please do not hesitate to ask.
Thank you very much, Mr. Osaki. Ms. Katani, would you like to respond to Mr. Osaki's point?
Yes, thank you very much. So I completely agree that SB 203 doesn't condition its requirement on the minor's affirmative request or lack thereof. That language is there just because law enforcement is already required, as you know, under the Fifth Amendment and Miranda, to, if someone, a defendant, not necessarily a defendant, but if a minor or any other person undergoing custodial interrogation invokes their right to an attorney, the understanding was that the government has to provide that attorney for them. So that's what that carve out is for existing law, not for any language in the statute itself.
And actually, I wish to clarify that point as well. So basically what it is that if the Miranda requirements requires the peace officer to notify, right, to advise the individual of their rights. If that individual invokes their right to counsel, then obviously one will be provided, but one will be provided at the arraignment. And so what happens is that the interrogation ceases. It is not the obligation of the peace officer to go seeking counsel for the individual at that point in time, because the law enforcement agency does not have the power to appoint counsel. The appointment of counsel occurs at the arraignment later on if their charges are brought forth. So I wish to clarify that point.
Oh, that makes sense. I think the only thing I would say in response to that is for SB 203, it also doesn't specify, I mean, for SB 203, I suppose that a law enforcement officer could comply with it by simply, as you said, ceasing interrogation until later on as well. It just prohibits them from having that custodial interrogation or proceeding onwards without that minor also receiving that legal consultation. So I'm not seeing, I guess, how that would be not overlapping with that existing Fifth Amendment right to provided counsel.
You want to respond to that, Mr. Osaki?
Well, you know, basically what it is that the law enforcement agency, you know, under the prior law was not required to locate counsel or find counsel for a minor who requests one. Basically what had happened was that because you know, if the peace officer wanted to interrogate, they just simply had to notify the minor of their rights. If the minor invoked, then the interrogation stops, law enforcement ceases the interrogation, and then all attempts at interrogation ceases at that point in time. So that's just generally what happens. So there is no prior requirement of law enforcement to do anything. And what this law does is now require law enforcement to actively contact our office for consultation purposes prior to that interrogation. So that's what this law did. So there was no overlap before because there was no obligation of law enforcement to have to do anything before.
Ms. Shelton, do you want to?
Just to clarify the positions as I hear it and hear Mr. Osaki explain how the program works. So the way the proposed decision is written, it's that there is no new activity when the juvenile offender affirmatively requests their right to counsel at that point. And the way Mr. Osaki is saying is that under the statute, the test claim statute, there is still, regardless of whether the juvenile requests an attorney, there's still a new duty to contact the public defender's office or to contact an attorney, I guess, right?
That's correct.
To provide that consultation. If the commission wants to go interprets the statute similarly to Mr. Osaki, we would need to take it back and clarify that issue. I don't want to do that on the fly right here, but he's suggesting that that carve out be eliminated.
That's correct.
Yeah.
Thank you very much.
So maybe then to summarize, I think let's go to questions from the board, but it sounds like this is something that after this meeting, Ms. Shelton and Ms. Katani, you can talk to Mr. Osaki because it sounds like a minor technical fix that you can do between you. Am I understanding that correctly? I don't want to oversimplify it, but it sounds like we can, if there's a motion to adopt the staff recommendation, that actually works. And then after this meeting, you'll continue to talk to Mr. Osaki about this point. No?
Oh, no, it would be something that needs to be decided at the test claim phase because here we're defining what is new and what's a new program or higher level
Got
of
it.
service.
Okay,
So it's not
nothing
something
needs to be decided now.
Yeah,
I
it's not
understand.
something
Thank
that we
you.
can correct later. It has to be done before the decision is adopted.
It would
Got it. Thank
require
you.
further legal analysis and us taking it back actually to analyze it. This is the first time this argument has been
Yeah.
specifically raised in this manner. So we have not done that analysis.
I should also
Thank
clarify,
you.
as Heather is indicating, that there were no comments filed on the draft proposed decision at all. So
Right.
there were no changes between the draft and what you have here today.
Got it. Okay. So
So
we will,
normally that would be raised in the draft and then we would have the opportunity to address it before it came to the commission.
so there's been no opportunity to address this. We won't make any assumptions about whether or not it can be addressed because it requires further legal analysis, correct? Got it. Thank you, Mr. Adams.
Thank you, Madam Chairperson. I was going to ask the claimant if they had any language they wanted added to the decision before we adopted it, but I appreciate what Camila said, that do not want to do this on the fly. If I'm understanding this right, previous law, the public defender's office clicked in when the court assigned them, but now law enforcement can get them in prior to that. So it seems to me that if the city is wanting, or county is wanting language changed, I'm certainly supportive of postponing this and bringing it back. Thank you.
Well, I think there's, oh yes, please, Ms. Olson. And then
I
Ms. Nash.
just would like the county to let us know why they didn't have comments about this prior to this hearing. Because my sense is that they're given time to do that. I'm not saying that we should necessarily move forward with adopting the decision, but I'm just concerned about the process here.
Mhm. I actually appreciate that question, as am I. Does the county want to respond to that? Why wasn't, I mean, this has been obviously ongoing. If you could respond to Ms. Wilson's question, please, Mr. Osaki.
From my perspective, I just thought that we had addressed it already in the test claim. This particular point. So I did not know that we had to address it again. So, but again, I'm coming at this from the criminal defense point of view. I'm not. So from my point of view, I thought it had already been addressed at the when we initiated the test claim.
Well,
So-
no, but I mean, oh, sorry, Ms. Olson, please.
So then if that's the case, then I have a question for staff.
I would like to clarify something. Mr. Osaki is not the claimant. He is a witness for the claimant. So he would not be the person that files the comments. So it would be the person, right? I mean, maybe he'd be working with the person that files the comments because he's obviously the program expert. But it's the claimant that would normally file the comments, and the person that filed the claim would be in charge of organizing those comments. And the process goes that we receive a claim, we analyze it, we issue it for comment. This is all set in statute. And there's a period for all the parties to comment and raise any issues that they thought were not addressed correctly or completely, or any new issues. And at that time, then we take it back and review those comments and analyze them and prepare a proposed decision for the commission hearing. But in this case, nobody, not from finance and not from the claimant, filed comments on this matter. And so this is the first time we're getting comments.
And I will clarify that the test claim was seeking reimbursement for all, for juveniles even under the age of 15. It was not entirely, even though they never pleaded and they never filed a test claim on the 2017 statute, the statute that they pled was only the 2020 statute. So you can't just accept the test claim as stated because they're trying to get reimbursed for everything. And our job is to determine what prior law requires versus what the test claim statute now requires. So yes, if that point needed clarification, it was certainly a time to provide that clarification after the draft was issued, which it was issued in September 13th. So we've had over a month and a half of time. They have 3 weeks to file comments on the draft and have opportunities to ask for extensions of time if necessary, and stated for good cause.
Okay,
So-
so Ms. Olson, do you want to follow up with that?
I do.
Thank you.
So, Ms. Shelton, so does that mean that if we were to make a decision to adopt the recommendation today, I'm not saying that that's what I want to do, I'm just sort of trying to get some clarification here, that would in essence have standing because the claimants did not file comments on it? Or is it the case that we really shouldn't do that because this issue is raised anew and needs to be evaluated?
If this case, your decision is a question, this decision is a question of law. If there were litigation filed on this decision, a court would be reviewing that under the de novo standard. So you need to we obviously want to get the issue correct as a matter of law.
Okay.
It really shouldn't, depend on when comments are filed.
So
But
then,
what we're saying is that we're not made aware of this.
But when comments are
Disputed.
not, right, when comments are not made till now, what it requires is us to take it back and reanalyze it and bring it back to a future hearing, because we have not had the opportunity to do that yet.
so do you need a motion for that? Or do we just
Yes.
sort of, or does it just kind of go off the dot? Well,
No, we need a
I move that
motion.
the staff take it back and look at it again, given the comment.
Okay, alrighty. So we have a motion. Mr. Adams has another, we have a second. Any other public comment before I comment? No other public comment. So I'm a little bit, I understand that the County of Los Angeles, I don't think has been specific as to why this wasn't brought sooner. I do think that the way that this board works, it is really important that we follow this process. And I understand, Mr. Osaki, you're not the claimant, but I'd like to just ask then the claimant, you know, to the extent that this was an issue previously, I'd like to understand why it wasn't brought sooner in terms of a comment that we could have addressed before today. So I don't know if Mr. Lemus or Ms. Gonzalez, if someone else wants to address that. I'm a little bit confused about how we are, just about the process on this and why it's so important to have a really strong process.
Yes, thank you, Ms. Miller. Yes,
Thank you.
at the beginning, at the onset of this roll call, both Mr. Lemos and I indicated that we were in favor of the commission's decision, and we accepted the commission's decision. Prior to this meeting, I did receive a communication from Mr. Osaki where he wanted to highlight what he thought was he wanted to make a clarification with regards to a statement that was on page 15 of the proposed decision, and was going to indicate on the record the clarification that he believed needed to be made. And so that was my understanding prior to having this hearing today. And in the course of his testimony, it has become apparent that there are some issues that were raised that you are correct, were not previously raised during the comment period. And we completely understand the importance of procedure. There's a reason why the regulations exist and why filing periods exist. And we, as a claimant, completely understand that. But it does appear that based on Mr. Osaki's statements, that there are some issues that were raised today that were not raised previously.
Can I get clarification on something? When you say page 15, do you mean PDF page 15 or hard page 15? The concern.
No, it's the point that I made. It's kind of was raised a couple times, but I just saw it really quick here on page 15 of the decision itself.
Okay, so the clarification I have, the question just to be, so that I'm really understanding your point, is that if I go to hard page 15, the first bullet of the mandated activity says to ensure that youth ages 16 and 17 who do not affirmatively request an attorney consult with legal counsel prior to custodial interrogation and before the waiver of any Miranda rights. And your position is to remove the language that says who do not affirmatively request an attorney.
That's correct. That's correct.
Thank you.
Okay, well, we have a motion and a second. I will say I'm a little bit torn on this one because the county supports it. I think obviously, you know, there is another opportunity. So I'm debating whether or not to have a substitute motion, just where we would support staff recommendation and then continue the discussion as it moves along. Mr. Adams, I'm concerned about the process here just because it will complicate if we set a precedent like this, but I'd love your thoughts on that, Mr. Adams.
I understand. And I guess at this point in time, I'm going to ask if the staff has a recommendation of what they would like us to do.
Thank you. I appreciate that. Ms. Shelton, Ms. Halsey.
Well, I think this really comes down to what the commission thinks is right to do. Part of the process is the hearing and the testimony at the hearing. And so there could have been new things that came up at the hearing, even if comments were filed, possibly that you would want addressed. I can argue it both ways, honestly. It is something that we really do need. It is important that people review the drafts and submit comments timely, but it's also important that we have a thorough hearing of the issues. So.
Ms. Shelton, do you have anything you want to add to Mr. Adams and my question about?
Only that the issue that is being raised is a legal issue. So I can't, it's not something that if, without us taking it back and looking at it, I can't say one way or the other right now, whether the county's position is legally correct or not. And then if you adopt something today, I can't go back and change, I can't change it. So if you adopt this today, it is what it is.
Right. Well, that's really helpful. So I think I'm then willing to support the motion that the direction is to staff to take it back and review the points with Mr. Osaki, but I'd like to do it with sort of an admonition to folks that the reason this process works is because of how complicated these issues are, and having really adhering to the comment process, I think, is really important, just because we never want to do legal analysis on the fly. And I think it is really important. And obviously the county knows that. And I do appreciate, Ms. Gonzalez, your comments here as well. Those were really helpful and clarifying. So anyone else, any other further public comment? It was moved by Ms. Olson, seconded by Mr. Adams, that we send this back to staff for review to consider at a later date. Anything else? With that, just making sure, Ms. Palchak, nothing, you don't see anyone, correct?
I see nothing, Madam Chair.
Great, thank you. With that, Ms. Halsey, will you call the roll, please, on the motion to send back to staff?
Mr. Adams,
Aye.
Ms. Miller,
Aye.
Mr. Morgan,
Aye.
Ms. Nash,
Aye.
Ms. Olson,
Aye.
Mr. Silva,
Aye.
Mr. Walker.
Aye.
Great, so the motion is carried to send this issue back to staff for consideration. We will now move on to item 4, please, Ms. Halsey.
Sure. Will the presenters for item 3 please turn off their videos and mute their microphones. And next is item 4. Senior Commission Counsel Elizabeth McGinnis will please turn on her video and unmute her microphone and present a proposed decision on an incorrect reduction claim on interagency child abuse and neglect investigation reports, or ICAN. At this time, we invite the parties and witnesses for item 4 to please turn on their video and unmute their microphones.
Hi, good morning. This incorrect reduction claim challenges the controller's reduction of
So
costs.
Ms. McGinnis, I'm just going to ask that you just slow down just a little bit, just for our court reporter. Thank you, Ms. McGinnis, and welcome.
Sure. This incorrect reduction claim challenges the controller's reduction of costs claimed by the city of South Lake Tahoe for the Interagency Child Abuse and Neglect Investigation Reports Program for fiscal years 1999 through 2000 through 2011 to 2012. This IRC and decision are limited to findings 2 and 3 in the controller's audit report. At issue are the controller's reduction to the number of suspected child abuse reports investigated by the claimant for purposes of reporting cases that are not unfounded to the State Department of Justice, and reductions made to indirect labor costs. Specifically, the claimant challenges the following: the controller's exclusion of child abuse reports generated by mandated reporters within the claimant's police department, the reduction of child abuse reports generated by other agencies where the police department performed a full initial investigation, and third, the exclusion of the public safety dispatcher and evidence technician positions from the indirect cost pool. Staff finds that the controller's reductions are correct as a matter of law and are not arbitrary, capricious, or entirely lacking in evidentiary support, and therefore recommends that the commission deny this IRC. Thank you.
Thank you very much. Ms. McGinnis, parties and witnesses for this item, if you'll please state your names for the record. Ms. Chin, Lieutenant Roberson, and Ms. Tikamarova, I really hope I pronounced that right. Please forgive me, Tikamarova. For the city of South Lake Tahoe, would you like to begin?
Good morning, Annette Chin from Cost Recovery Systems Consultant for the city of South Lake Tahoe. I'd like to thank you all for your time in considering our incorrect reduction claim. We realize that the commission has reviewed other incorrect reduction claims on the same program in the recent past, so I will limit my comments and request for consideration to the 2 topics that are unique to this filing and have not yet been touched upon in prior reviews. These two areas are the reduction of our indirect cost rate, which by the 100% exclusion of dispatch and evidence staff lowered our allowable costs by approximately 20%. And secondly, the request for reimbursement of costs we believe were reasonably necessary to comply with the mandate's primary requirement, which was to conduct child abuse investigations. First, on the topic of indirect costs, the bottom line here is that the state auditor mistakenly found that none, 0% of the police department's dispatchers and evidence technicians were eligible for inclusion in the overhead or indirect cost rate. There was nothing wrong with our computational methodology. Our rates were departmental. I provided copies of the ICRPs from all the other claims we filed so that you can see that the rates were the same for all the state mandated programs we claimed for and were all computed exactly the same way. There was no different methodology from one claim to the next. The rates were all departmental and all applicable to all police department claims. Dispatchers and evidence technicians are a necessary and allowable police department support cost, whether the cost objective was the department as a whole or for the specific child abuse claim. Under either scenario, the positions were necessary for the police department to function, for officers to perform their law enforcement duties. Without them, police officers could not fulfill the mandate nor do their jobs. These positions met all the definitions of an indirect cost. The claiming manual instructions address the indirect costs in section 8B and states, I quote, "The indirect cost pool may only include costs that can be shown to provide benefit to the program. The proposal must follow the provisions of OMB Circular 2 CFR Chapter 2 and 1 and 2, Part 200, formerly Circular A87. It requires that indirect cost pools include only those costs which are incurred for a common or joint purpose that benefit more than one cost objective. The indirect cost pool may include only costs that can be shown to provide benefit to the program. In addition, total allocable indirect costs may include only costs that cannot be directly charged to an identifiable cost center, i.e. program." We checked the boxes on all of those points. Yes, 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 yes. We provided a vast amount of evidence showing that dispatchers and evidence staff did indeed meet the definition of all allowable indirect costs. Our documents included organizational charts that list records, dispatch, and evidence under the support services division of the department. We have provided job descriptions, police command staff declarations that explain that dispatch and evidence staff provide necessary support to all sworn staff. We provided job descriptions from other agencies so it can be compared that all these positions are performing similar tasks from agency to agency. We have shown excerpts from federal CFR guidelines that advise that pooled clerical, administrative, and support staff be considered eligible overhead costs. I highly doubt that anyone would believe that dispatchers and evidence staff are not necessary police department support and overhead costs. I would ask the State Controller's Office to explain how the definition of a cost objective or methodology would have changed the eligibility of dispatchers in the overhead rate. In fact, their argument that the rate is departmental further justifies inclusion of these two positions in the ICRP because no police officer could function without the support of these two job classifications. The last paragraph, the last sentence of the State Controller Audit Report sums up clearly the issue here. I quote, from the State Controller Auditor, we believe that the classification of public safety dispatcher and evidence technician perform duties that are direct in nature and specifically identified with a particular unit or function. Therefore, we believe that we properly classified these positions as direct in our computations of the ICRPs for the audit period. This is the problem, not the cost objectives or the methodology. The bottom line is that the auditor made a mistake. They got confused by the definitions and didn't look at the function or purpose of the positions. They just saw that they were identified with a specific unit or function. Thus, they thought that they were not an indirect or support cost. But this is not how you determine what an indirect cost is. Being specifically identified with a particular unit or function doesn't relegate it to being a direct cost, as the auditor mistakenly believes. It is the purpose or the function of that position. In fact, claiming instructions note in section 5E under indirect cost rates, part 2, page 16 of the claiming instructions, the allocation of allowable indirect costs can be accomplished by 1, separating a department into groups, such as divisions or sections, and then classifying the division or section's total cost for the base period as either direct or indirect. End of quote. CFR guidelines provides additional detail and examples on how you can take an entire division, such as administration or facility maintenance, and put those entire divisions into the overhead rate computations. I have been a consultant in the area of state mandate reimbursement claims for over 25 years. I have personally been involved in almost a dozen law enforcement audits, including audits on this exact same child abuse program. And in all these other audits, the majority of costs for dispatcher and evidence staff were allowed in their overhead rates. The purpose of having uniform standards, guidelines, and instructions is so that the claimants are treated consistently and fairly in the recovery of costs and in the conduct of audits. Federal CFR guidelines begin by stating in section 225.2 policy, quote, this part establishes principles and standards to provide a uniform approach for determining costs, end of quote. This did not occur in the city of Lake Tahoe's case. Under any ICRP computational methodology or metric, dispatch and evidence personnel costs should have been considered an eligible support cost to the police department, as was claimed by the city. All law enforcement agencies operate similarly. All have dispatch personnel that serve as the department's central communications unit. All have evidence staff that maintains evidence for all department cases. Commission staff argue that the state controller's decision to deny the city's cost of dispatchers and evidence staff was not arbitrary and not capricious. But isn't it arbitrary to not treat similar costs consistently from agency to agency? Isn't it arbitrary if the same standards and guidelines are not applied uniformly? We believe we have shown that there was inconsistent treatment of like costs in this circumstance, which did not comply with the written state and federal guidelines. South Lake Tahoe, by having 100% of these positions omitted, was treated differently and unfairly. This resulted in an approximately 20% disallowance of eligible costs. The city should not be penalized for an erroneous decision on the part of the auditor. The purpose of having uniform standards, guidelines, and instructions is that so like costs are treated consistently, agency to agency, and that arbitrary decisions are not made regarding application for funding. The claimant should be treated fairly and consistently in the recovery of costs and in the conduct of audits. We request that the commission remand this specific issue back to the state controller's office for correction so the city may be reimbursed for their full allowable indirect costs as guaranteed by state mandate law. Should I continue on with our second issue, or would you like to stop at this point and discuss this topic?
Why don't we do both issues and then we'll discuss both topics?
Okay. So the second issue we'd like to present to the commission for review is the disallowance of investigative costs incurred by the city that took place prior to the actual in-person interviews with parties required in the child abuse investigation. Roughly 90% of the city's child abuse cases did not require staff to conduct in-person interviews. For those 90% of the city's cases, only time for the detective to review the suspected child abuse report, the SCAR, was allowed. To have the sergeant approve and close the case, and 3, provide record staff time to document and close the case. However, none of the actual investigative activities to arrive to their conclusion that the case should be closed without further interviews were allowed for reimbursement. These activities we requested were time to, let's see, a detective would ask record staff to check to see if a report was already written so that they would avoid a duplication of effort. Then the second issue was the detective would check prior history and determine if the case was actually in the agency's jurisdiction and confirm that the investigation had not already been investigated by the department. This would often require phone calls to other agencies, and they would also work with records and dispatch to determine the history of the case. And then finally, then the detective or the sergeant would contact the Department of Social Services, the reporting agency, or involved individuals, at least one adult who has information regarding the allegations, to obtain more details of the case to determine if in-person interviews were necessary. So the detective and the lieutenant must decide how to proceed on each case. So these steps were not allowed in our claim for reimbursement. The process took approximately an hour of time per case. And we disagree that this determination and believe that it should have been allowed as it was reasonably necessary to perform the mandate. The city contends that these preliminary investigative activities listed above were reasonably necessary for investigators to make the determination whether to close the case or to continue the investigation by proceeding with in-person interviews. We believe this request is also supported by the Commission's own statement of decision, where they conclude on page 37, and I quote, "Therefore, because in-person interviews and writing a report of findings are the last step taken by law enforcement before determining whether to proceed with a criminal investigation or close the investigation, and the last step that county welfare departments take before determining whether to forward the report to the DOJ and possibly refer the matter to law enforcement, that degree of investigative effort must be the last step that is necessary to comply with the mandate." This is exactly what we requested for reimbursement. The California Department of Social Services explained their procedure and note in the statement of decision, and again, I quote, "Prior to actual interviews, the social worker must make a multitude of considerations to first decide whether an in-person investigation is necessary. Social Services also explained that they must, quote, contact at least one adult who has information regarding the allegations. If after that stage, the social worker does not find the referral to be unfounded, the social worker must conduct an in-person investigation," end of quote. This is the same process that the city describes. These are all part of the investigative process that must take place in order to close the case. These steps all occurred before the determination to close the case occurred, and therefore those steps should be allowable for reimbursement at the approximately 1 hour of time requested. We believe that our request to be reimbursed for these activities were reasonably necessary and request the commission allow them in our costs.
Great. Thank you very much for all of that, Ms. Chin. We appreciate it. Next, before we go to comments, Ms. Kearney for the State Controller's Office, if you could respond to some of the claims, please.
Sure. Lisa Kearney from the State Controller's Office. I first want to state that we do agree with the Commission's proposed decision for this IRC. Regarding the indirect costs, I want to state that for the dispatcher and the evidence technicians, we determined based off of extensive interviews and based off of the duty statements that the classifications perform duties that are direct in nature and can be specifically identified with a particular unit or function within the police department. And also the classifications do not perform general business functions that benefit the entire police department. So we found that the claimant is interchangeably identifying the cost objective as the child abuse program and the child abuse investigations. And they're arguing that the dispatch and evidence technician classifications benefit more than one cost objective, despite the fact that the claimant's claimed rates and the SCO's audited rates were based on the police department's expenditures as a whole, meaning the cost objective is the entire police department, not the ICANN program. And under this rubric, direct labor includes the overall functions of the police department assignable to the specific units and functions, and indirect cost rates are department-wide rates. And additionally, no additional documentation has been provided. Therefore, we think that indirect costs should remain unchanged, that they should be at 0% for both of these classifications. In regards to the additional preliminary activities that they are seeking reimbursement for, we determined that those preliminary investigative activities are not identified as reimbursable activities in the test claim, and therefore they're out of scope of the mandate, so they are not reimbursable.
Great, thank you very much, Ms. Kearney. Anything else?
Not at this time.
Thank you for being here today. Mr. Nichols, as an interested person, did you have anything you'd like to add at this time or any comments?
Madam Chair, I do not see Mr. Nichols on as a panelist, or do I see him as an attendee? And I don't see any hands raised anywhere to speak.
Thank you, Ms. Palchik. I appreciate it. You got to my next question around if there was anything. So I think, are there any questions from the board, any clarifying points from Ms. Chin, Ms. Kearney, or Ms. McGinnis? Please, Ms. McGinnis.
Hi, just because there's a lot going on in this claim, I just want to refresh the board's recollection as to what the proper standard is that's being employed here, and also just to point out that none of the comments raised today by either of the parties are new. All of these, and we appreciate how much work was put into these, because I know there's a lot going on. All of these comments and the evidence that's referenced was provided in both the IRC and then in late comments that were filed by the claimant. So staff has reviewed all of these legal arguments and all of the supporting evidence. And I haven't heard anything today that would change the analysis and recommendation that staff has made in this matter. And in regards to the standard that applies for both of these issues, both the two positions that are being challenged as whether or not they are indirect and should be factored into the indirect cost rate proposal, and for the alleged additional activities, investigative activities that should be reimbursed. The standard that applies here is both a legal standard and a factual determination. So it is the commission's duty to look at whether or not the controller correctly applied the law, whether they correctly interpreted the parameters and guidelines, and whether in making these determinations, whether the controller acted arbitrary, capriciously, or did not have sufficient evidentiary support. Again, I have not heard anything today that would change my recommendation, but if you have questions or would like additional clarification, I'm happy to do so.
Great, thank you. Any questions from the board? Seeing none, Ms. Chin, do you want to respond to anything?
I guess I am confused by the inconsistencies of the state controller's office. I'm confused by how in all of the other audits that I've been a part of, and in all the other audits I've reviewed online from other agencies, how those cities can be allowed costs for these positions, for dispatchers and for evidence technicians, and how any reasonable person who is familiar in any small way about the operations of a police department, how anyone could reasonably believe that a police department can function, that the officers can do their jobs without the efforts of dispatch and evidence. Every time an officer goes out for a call for service, they are tracked they are in constant communication with those dispatch staff. The dispatchers are logging in every communication from that incident, and they're documenting everything that happens. They're keeping track of those officers. They're the critical link between an officer being out in the field and the department. If there's a need for backup, that position is there to assist them in those things. An officer could not do their job without those positions. In theory, you could go through your records and find out exactly how much time every dispatcher is touching each and every case. And you can compute that and come up with some kind of method to request reimbursement for those costs. However, to do that would take an exorbitant amount of labor. You would have to probably hire a person to do that in order to compute the costs for reimbursement. So in order for local agencies to not have to do some onerous calculation of costs, the state and the federal government created something called the indirect cost rate proposal, where you could distribute those costs that are used by and benefiting all the department's officers for those costs. It's the same for paper and utilities and facility use and equipment. All of those things are necessary for a police department to operate. And the officer could not do their jobs without those positions. So it just seems completely illogical, unfair, and inconsistent. And if the commission can't see that, then I don't think there's anything, as the commission, Ms. McGinnis stated, that if you don't see that there is overhead in these positions, and you don't see in the job descriptions in the departmental unit, it shows that records, dispatch, evidence are a support unit of the police department. And if now those costs are considered ineligible in one case, but eligible in 99% of all the other cases, then that is an inconsistency. And that is what we seek the commission to consider and to remedy. we're not asking you to disallow all these other costs as a part of our claim, but we're just asking for a reasonable review of this and a reasonable decision. And again, if commission staff can't see the basic reason, then there's.
Yeah, I think oftentimes, you know, I think that's somewhat inappropriate, Ms. Chin, just because this isn't about what we see. This is a matter of law. But why don't, Ms. McGinnis, if you want to go ahead and comment on that, please, and then
Yeah,
Ms. Shelton, I see you popped up too.
So I would just say, and Ms. Kearney with the controller can correct me if I'm getting this wrong. But I would just say that my understanding here is that the fundamental disagreement between the parties, which originated with the original audit report, is a disagreement as to whether these two positions provide necessary support to sworn staff in the commission and law enforcement duties, such that that constitutes an indirect or direct cost. So there's a fundamental disagreement with how the direct cost definition and the indirect cost definition in the parameters and guidelines, which originates in the federal regs that Ms. Chin referenced, whether or not those definitions are being correctly applied to the facts here. And my understanding of the controller's position, which staff has tried to clarify repeatedly in this decision of ours, is that these positions provided direct support to sworn officers of the police department in carrying out calls or requests for service. So that is not the same as a general receptionist, as somebody who is answering phones for any call that comes into the police department. And I'm specifically here referring to the public safety dispatcher, because that is the only position that the claimant provided further evidence on to try to show why this was an indirect rather than a direct cost. So again, I think the fundamental disagreement here is whether or not carrying out a support role to a position that performs direct duties, that responds to calls for service for domestic violence, for an assault, for suspected child abuse, and so on, whether or not that satisfies the standard of direct and providing services that benefit a particular function or particular programs within the department, or whether it provides a indirect or general support role.
I think you've just answered the question. Yes, those positions definitely provide support for the whole department. It's not for one specific unit or function that the dispatcher is functioning. The dispatcher is there for the entire law enforcement staff. All law enforcement officers require those positions to provide them support. And those are the same positions that have been found allowable in 99% of all the other audits, that if you look at the state website with all the other audits, and maybe Ms. Kearney can tell us, give us an example of another jurisdiction that had their dispatch and evidence staff removed from their claims, because in all of the audits that I examined, it did not occur. It only occurred for the city of South Lake Tahoe. And I just believe that it was a mistake, that there was maybe an auditor who didn't understand what it was they were reading, that they read the section on direct costs and they just misapplied a definition, and it was a simple error. And you know, if it's impossible for a local agency to come to this body to have like a fair resolution of disputes between the state controller's office and local agencies, then it's really a grave disservice, because this is the only body available for local agencies to come with these types of disputes. So
well, I would just, Ms. Chen, I would respond to that it is not within the purview of this commission to disturb a factual determination made by the controller unless additional evidence is presented to the commission that would cause the commission to find that in reaching that determination, the controller acted arbitrary, capriciously, or entirely lacking in evidentiary support. So in other words, this commission does not have the authority to step into the shoes of the controller and second guess a decision that they've made. This commission is not permitted under our authority to do that. So our review is more limited. We have to have specific evidence that would show that there is arbitrary, capricious, or entirely lacking in evidentiary support. And staff has, sorry, if I may finish, staff has not found in this instance that there was sufficient evidence presented to make that determination.
Great. Okay.
Just to clarify real
please, Ms.
quickly,
Shelton.
under the arbitrary and capricious standard, we are not looking at this brand new, like a legal question or a question of law. We are forced to defer to the controller's audit findings. What that means is all that we have to look at with these audit decisions is if they considered everything that you're just raising and discussing in all of your documentation, and they didn't miss anything, and they establish a reasonable connection between their conclusion and what they're finding. And that's it. We can't, even if the commission were to disagree with their conclusion, we don't have the authority to overturn an audit decision. So your standard is very limited on these audit findings.
So Camille, you said whether there is a reasonable connection between their decision. What if
A rational connection between the factors between all the evidence and their decision. And they have a reason, let me say, they have a reason for what they did. And we don't have any evidence to show why that is wrong. We can't disagree with them. They have a reason. As long as they have a reason that is reasonable, then that's the limit of the commission's authority.
So what if that reason was not reasonable? And what if that reason was not consistent? What if we showed through all these other audits that it was not a consistent decision, that these are the police departments, same police departments, different departments, all the same function, yet they're treated inconsistently? Is that not unreasonable? And is that not an inconsistent decision?
So you're certainly allowed to raise that issue. However, we don't have those audit reports in this record. We never had to look at them. I have no reason to understand why the controller may or may not have done something different in a different audit. So
Yeah, and this point, again, just for commission members, this point was raised in the comments that were filed by the claimant, and staff did address this in the proposed decision. So we have looked at several hundred pages of additional documentation. The controller's decision as to a different local agency in claiming costs for this program is not something that the commission can consider in reaching its decision today. Those cases involve their own legal and factual issues that are not before the commission. So that is not an appropriate point of reference or relevant evidence for the commission in reaching its decision today.
Okay, thank you very much for that robust discussion. Any other questions from the board? Mr. Nichols, were you able to make it on? Do you still not see him, Ms. Palchuk?
Madam Chair, I do not see Mr. Nichols anywhere. I do see just a call-in number, Mr. Nichols. If you are indicating yourself as a call-in number, if you would raise your hand. If not, we do not know that you are here in the meeting as an attendee, but I do see Member Olson's hand up.
And you should be able to do *9, Mr. Nichols, if that's you on the phone, in order to indicate a raised hand on the interface. Ms. Olson, please.
So I am sympathetic to what has been expressed by by South Lake Tahoe and Ms. Chen. But I do think that the commission is kind of stuck in terms of what we can and can't do. And so I regrettably am going to move the staff recommendation.
Thank you for that. Do we have a second? Thank you, Mr. Walker. Any further public comment? The staff recommendation has been moved by Ms. Olson, seconded by Mr. Walker. Ms. Halsey, will you call the roll, please?
Mr. Adams,
Aye.
Ms. Miller,
Aye.
Mr. Morgan,
Aye.
Ms. Nash,
Aye.
Ms. Olson,
Aye.
Mr. Silva,
Aye.
Mr. Walker.
Aye.
Great, that motion is carried to adopt the staff recommendation. We'll now move to item 5, please.
We now ask the presenters for item 4 to please turn off their video and mute their microphones. Item 5 is reserved for county applications for a finding of financial distress or SB 1033 applications. No SB 1033 applications have been filed. Next, Chief Legal Counsel Camille Shelton will please turn on her video and microphone and present item 6, the Chief Legal Counsel report.
Great.
Good morning.
Thank you, Ms. Shelton. Good morning.
There have not been any new filings since the last commission meeting. We do have a new decision that was issued by the 3rd District Court of Appeal in the Department of Finance versus Commission on State Mandates case dealing with discharge of stormwater runoff. There, the court affirmed the commission's decision except for the activity of street sweeping, which is reversed, consistent with the court's earlier decision in Paradise Irrigation District on the ground that the claimants have sufficient fee authority pursuant to 17556D. On November 21st, following a request by interested parties, the court did certify this decision for publication. At this time, we don't have any cases pending on our hearing calendar, and that's all I have today.
Great, thank you very much. Any questions from Shelton? No, seeing none. Any public comment?
I see none, Madam Chair.
Thank you. Next, we'll move to the Executive Director report, please.
Hello, today was the first commission meeting for our new Information Technology Specialist 1, Chris Steinwert, who I thought did a great job of running the meeting today in Jason's absence. Welcome and thank you, Chris. Also today is Mariko Katani's last day with the commission. She's taking a promotional position with Legislative Council. Additionally, since we last met, our long-serving office technician, Lorenzo Duran, took a promotional position with the Business Services Office of the State Public Defender, and our accounting analyst, Pranati Saxena, also took a new position with the Caltrans Contracting Unit. The commission is now in various stages of the recruitment process for 5 positions. 2 program analysts, that's our procurement and accounting analysts, an associate budget analyst, an attorney, and office technician. And that's about 1/3 of our staffing. Also, after this hearing, we have no more IRCs pending.
Great, that is a huge accomplishment. We're so impressed.
Yeah, so that ICANN was our last pending IRC. For those commission members who've been around for a long time, it used to be that we had hundreds of IRCs pending. So this is the first time since I've worked at the commission that we've had none. So it's kind of a big deal. Also, there are 39 pending test claims, and 38 of those are regarding stormwater and PDES permits. There's also 1 amendment to parameters and guidelines and 1 statewide cost estimate active and pending. And then there is 1 additional parameters and guidelines regarding stormwater and PDS permit, which is on an active status pending the outcome of litigation that is currently pending. Commission staff currently expects to complete all pending test claims by approximately the December 2025 commission meeting, depending on staffing and other workload. However, some of the test claims may be heard and decided earlier than currently indicated if they're consolidated for hearing, and which will be determined at a later time. For tentative agenda items, please check the executive director's report and see if an item you're interested in is coming up in the next couple of hearings. Please also note that the parameters or the amendment to parameters and guidelines for racial and identity profiling is tentatively set for the January hearing, but was inadvertently left off the executive director report. You can access the pending caseload documents for or for all matters on the commission's website, and those are updated at least bi-monthly, and you can see when all matters that are pending are tentatively set for hearing. Please expect to receive draft proposed decisions on all test claim and IRC matters for your review and comment at least 8 weeks prior to the hearing date, and a proposed decision approximately 2 weeks before the hearing. And that is all I have.
Great, thank you. Any questions for Ms. Halsey? Seeing none, we are now going to adjourn into closed session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. We'll also confer on personnel matters pursuant to Government Code Section 11126A1. And we will reconvene in open session in approximately 15 minutes. And we will be back to report out from closed session then. I don't see on my calendar invite the closed session link. Oh, I do actually. It's at noon and it was sent by Ms. Palchuk, just so everyone knows that you do have the closed session link within your calendar. So for board members, if you can leave this Zoom link and join the one in your calendars.
And just to let me clarify, if you don't have it
Yeah.
on your calendar, you should have it in your email to accept, and it came this morning.
Great, thank you very much. We'll see you in a moment in closed session. Thank you, everyone. think we have a quorum. I can go ahead and get started, right, Ms. Palchek? I think so.
Yes, Madam Chair, the meeting
Great.
is open and being recorded.
Thank you very much. Thank you, everyone, and welcome back. The commission met in closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The commission also conferred on personnel matters pursuant to Government Code Section 11126A1. With no further business to discuss, I will entertain a motion to adjourn, please. I'll move to adjourn. Is there a second?
Second.
Thank you, Ms. Olson. It has been moved and seconded that we adjourn the meeting. And Heather, do you want to call a quick roll call, please?
Sure. Mr.
Thank
Adams,
you.
Aye.
Ms.
Aye.
I'm sorry, Ms. Miller,
Aye.
Mr. Morgan,
Aye.
Ms. Nash,
Aye.
Ms. Olson,
Aye.
Mr. Silva,
Aye.
Mr. Walker.
Aye.
Thank you.
Great. We are adjourned. Really appreciate everyone today. Congratulations to Mariko. We really appreciate your service to the commission. You will be missed. Thank you, thank you, thank you, and take care, everyone. Have a good
Happy
day.
holidays, everyone.
Oh, yes,
Bye.
happy
Happy
holidays.
holidays.
See you next year. Bye.
Thank you. Bye.